Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists. And as uncertified podcast co-hosts, we try to bring our audience of trial and appellate attorneys some news and insights they can use in their practice. If you find this podcast helpful, please recommend it to a colleague.
And a quick thank you to our sponsor, CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse their service. And listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
All right, Jeff, we've got some recent cases and tidbits to share with our audience today. So let's get right into it. The first case that we're going to be talking about involves a summary judgment that was not appealed, but it got reversed anyway. So this is very unusual, Jeff. The case is Magyar versus Kaiser Permanente Medical Center. What happened here was there were two summary judgments, and they were entered 6 days apart. So this was a slip and fall case outside the parking structure outside of a doctor's appointment. The plaintiff sued both Kaiser and the operator of the parking structure, Modern Parking, and the trial court granted summary judgment in favor of both defendants. But this sometimes happens, not a lot, Jeff, but every now and then you'll get two different judgments. Each defendant here, for whatever reason, submitted their own separate proposed judgment. And the trial court, instead of just sending it back and said, give me one proposed judgment that I can sign and be done with, the trial court signed both of them, but didn't do it on the same day. Entered one on September 15th and the one against Modern Parking on September 21st. 6 days later. The plaintiff appealed from the first summary judgment, but apparently neglected to appeal from the second. The court said that ordinarily this means that the second judgment was outside the court's jurisdiction to review on appeal, but under the liberality doctrine, the court inferred that plaintiff probably intended to appeal from both because there was, quote, nothing that would logically and conclusively demonstrate that plaintiffs intended to appeal solely from one of the judgments. End quote. So, for example, there's authority that when there are two judgments entered on the same day, the doctrine of liberality requires that the court construe the notice of appeal to mean both judgments are intended on the notice of appeal. But here, the orders were not entered on the same day. They were entered 6 days apart. There's, in fact, another case that's analogous where the two orders were entered 44 days apart. And the court said, no, the liberality doctrine does not reach that far. So this is the first case that answers the question. If two judgments are entered on the same day, then the notice of appeal will be construed to mean both. If there's a judgment entered on one day and another appealable order entered 44 days apart, then the notice of appeal will not be construed to apply to that 44-day later order. But the answer to the question is 6 days closer to simultaneous or closer to 44 days? Simultaneous, it's that's a different beast, right? But 44 days, 6 days, it's all more than simultaneous. Anyway, this is about the broadest application of the liberality doctrine that I've seen. It starts from the curious assumption that all judgments are contained in the notice of appeal unless something in the record, quote, logically and conclusively demonstrates otherwise. And Jeff, that just seemed off to me.
Well, it depends on which side of the V you're on. As an appellant's attorney, it's not terribly off. I will say I'm super frustrated by this doctrine. I have a case right now where the trial court inexplicably signed two identical judgments months apart. And the notice of appeal only identified the later judgment, not the earlier judgment. I brought a motion to dismiss because, hey, the earlier judgment was the first word on the matter, and that's the one that should have been appealed from. And the Court of Appeal said, nope, at least in response to the motion to dismiss. Maybe in the briefs on the merits, it'll deal with it. But I've come across this liberal doctrine before, and I guess as an appellant's lawyer, it's nice to have that breathing room.
Well, it is, and I can sympathize with it. But Jeff, you know that my hobby horse here is that the court's always, when it is going to dismiss the appeal, it will stand and get up on the soapbox and say it's because this is a jurisdictional rule, and as much as we would like to reach the merits, sorry, we just can't do it. We can't make an exception because the exceptions are only provided by the legislature. We don't get to make it up as we go, but this liberality doctrine is an exception made up by the judiciary.
Yeah.
So it's incongruous to talk about the appealability and timeliness of appeal rules as jurisdictional when you have an expanding liberality doctrine in the offing. All right, the next case. One other point about this case, Jeff. Sometimes we've talked about whether litigants should use the judicial counsel form notice of appeal, and I've told you that I've changed my practice and I stopped using it by default. But in this case, it actually helped the appellant to use the judicial counsel form. The court noted that the court found it important that the plaintiff's notice of appeal using that form, and remember that form has all those boxes you have to check. What type of judgment are you appealing from? Is it a judgment after a jury trial? Is it a judgment after, is it following a post-trial motion? Is it a judgment following a summary judgment motion? And in this case, the plaintiff checked the box for, this is a judgment after an order granting a summary judgment motion. So the court didn't go into detail explaining why it found that significant, but I got the impression that the court felt that because cases ordinarily terminate with a single judgment, the plaintiff appellants here should not be made to cower in fear of there being piecemeal judgments, where the plaintiff would have to take an appeal from each one. When there's a judgment following an order granting summary judgment, that ought to be the one final judgment.
Yeah, that same judicial counsel form also has a space for the date of the order or judgment you're appealing from. So I don't know that this use of the form or the court's interest in the use of the form really helps me understand the outcome here.
Well, that's fair. As I said, the court didn't explain why it found it interesting. It only said that it found it notable.
I still recommend my clients not use that form.
Yeah, I do as well. Okay, next case. Jeff, you and I both flagged this case as interesting. The upshot here is that there is no such thing as a corporate representative or a person most qualified witness when you are the moving party in a summary judgment motion. So here's what happened in Ramirez versus Avon Products, Inc. This is a published decision out of the 2nd District, Division 8. A trial court relied on a hearsay declaration when it granted summary judgment to Avon in this talcum powder case alleging asbestos exposure. And what happened is that the important takeaway from the published Ramirez opinion is that corporate litigants cannot get around hearsay and foundation problems by designating their witness a corporate representative or a person most qualified. These are deposition tools, not end runs around the rules of evidence. So what happened is that Ramirez alleged asbestos exposure dating way back 50 years ago to the 1970s. Avon offered the declaration of a vice president by the name of Lisa Gallo, but Gallo had only worked at Avon since the 1990s, which is pretty long tenure as it is, but it still didn't go all the way back to the age of the plaintiff's allegations in the 70s. So Ramirez objected when Gallo submitted a declaration about goings-on of the company in the 1970s where she had no foundation or personal knowledge. So the plaintiff objected on hearsay and foundation grounds, but the trial court overruled those objections, concluding that Avon had designated Gallo as its corporate representative and the person most qualified on those topics. And besides, the events happened 50 years ago, so it's not likely that Avon's going to have people still around who were privy to the goings-on personally in the 1970s. But the Court of Appeal didn't buy it. Didn't buy that the trial court could get around the foundation and hearsay objections just by dubbing a witness a corporate representative or a person most qualified. The Court of Appeal said that the evidence code recognizes only two types of witnesses, lay witnesses and expert witnesses, and Gallo was not offered as an expert. And the court went on to say that there's no special category of quote-unquote corporate representative witnesses, as the trial court had suggested. There's no exemption from the evidence code for a witness who has conducted an independent rule. Gallo had said that I conducted an independent review and this is what I found. Court said that does not get around hearsay and foundation objections, whatever is meant by independent review. What about a person most qualified? Attorneys are familiar with that concept when seeking information from an entity defendant via deposition. And if Ramirez had deposed Avon, seeking that same information that Gallo had submitted in support of the summary judgment, then Avon presumably would have offered Gallo to testify to the very same matters as in her supporting declaration. So why can't Avon do the same thing without having the deposition been taken first? The answer, the court explained, is that the tools available in deposition are for discovery, not to give the deposed party an end run around the evidence code. So, Jeff, you want to pipe in here?
Yeah, no, it's a super interesting case. When the trial court, said, well, an independent review was done. The Court of Appeal doesn't buy that as a replacement for foundation and laying a foundation for personal knowledge. I wonder, did the declarant literally say, I did an independent review, or could a declarant avoided this result by saying, I have access to the corporate files going back to the 1920s. I've read each one. I spent 3 days reading each one, and I now have personal knowledge regarding the events set forth. Or is it just a matter of getting those documents in front of the judge in exception to the hearsay rule? I just wonder what the solution is to the gate that's been slammed down by this case.
Yeah. The court didn't make a very clear path here, but I think what it suggested is that there is the business records exception to hearsay, but that was not established here. I think that maybe Gallo was not the custodian of the records, or maybe just didn't they didn't do the job in the declaration to lay the foundation for the business records exception. And besides, she was trying to get in, I think, more than just the documents would have supported anyway. And even some of the documents that the court did go later on in the opinion to discuss one of the particular documents that was full of hearsay, purported to be the conclusions of a scientist, but didn't talk anything about the qualifications of the scientist or the methodology, and pointed out that the scientist's conclusion sounded more like a PR statement than the conclusion of a scientific investigation. So for all those reasons, the court thought, no, these documents are not coming in under any exception. The groundwork hasn't been laid. There isn't the indicia of reliability sufficient to consider these enough to meet the burden of the moving party on summary judgment basis. And I just thought that Avon here, I thought had a point in sensing that something seemed amiss, because it pointed out that, look, plaintiff can depose Gallo for all this information, and then plaintiff can use the bits of Gallo's testimony that are supportive of plaintiff's theory of the case as party admissions, right? But then when Avon wants to use Gallo's same testimony to support its own case, it's barred on hearsay grounds and lack of foundation grounds. That seemed like that can't be the way it works, Avon said.
Asymmetrical warfare comes to mind.
Exactly. So the person most qualified can only be used by the person deposing the person most qualified. And the court said, yep, that's how it works. That's how it works. The person most qualified is a way for the party suing or being sued by the part on the opposite side of the V from the company to get information about the company to use in building its case. It's not for use by the company to get self-serving statements out into the record against the evidence code.
Well, yeah, look, the rules regarding PMQ depots, or PMK if you're an old dude like me, those are all interesting, but let's get down to it. We all know, everybody's listening to this podcast knows the real reason you want to discuss this case. It's not so much the result, but the standard of review for evidentiary objections.
I keep banging the table about the standard of review on evidence objections should be, at least for the matters of law like hearsay. Hearsay is black and white. If you want to do 352 objections are reviewed for abuse of discretion, I get that. I'll make that case all day long. But hearsay, foundation, those are all those seem black and white to me. And the court did go out of its way to note the split of authority on the standard of review of evidentiary objections made in connection with summary judgment, especially. With one side holding that the standard is de novo and the other side sticking with abuse of discretion. The Ramirez panel actually did not go in this direction, even though it found that the evidence was improperly admitted. It still sided with the majority of districts reviewing evidentiary rulings in summary judgment context for abuse of discretion. So my question was, why wasn't it within the trial court's discretion to consider the evidence in Gallo's declaration? Trial courts can consider hearsay all day long as part of its discretion, so why not here?
Yeah, that's a great question. I don't know why that wasn't the direction of this case. I don't know.
Yeah, and I wonder if it's because the court just decided maybe this was maybe the court didn't, because when the court admitted this evidence, it was thinking that that there was such a thing as a corporate representative witness who can get around the evidence code, and there was a person most qualified exception to foundation and hearsay objections, and the court said no. If you had just considered this evidence reliable for other reasons, then maybe we would consider it within your discretion. But you made an error of law because there is no such thing as a corporate representative exception to hearsay or a PMQ exception to hearsay. So you got the law wrong, Judge, and so that's why it's being reversed as an abuse of discretion, because an error of law in the reasoning is an abuse of discretion.
Yeah.
Okay, and the last case that I had on my list to discuss before I turn it over to you, Jeff, for your cases is the Flickinger versus Finwall case that held that a pre-litigation demand letter was not extortion. I always find these cases vexing, Jeff, because every now and then one of these pre-litigation demand letters is deemed to be extortion. And I just feel like there's not been a clear enough demarcation line. So anyway, I always think it's worth highlighting when cases come down on one side of the other on whether a pre-litigation demand letter is or is not extortion. So this is a case out of the 2nd District. It's a published case from November of last year, and there were unsavory allegations between a homeowner and his contractor. The owner, in a drunken conversation with the contractor, had confessed that he had taken money illegally as kickbacks during his overseas trips for his employer, Apple. The contractor thought, well, this seems kind of icky, but continued on the job for a while, but then eventually quit on the job before finishing, allegedly based on his trepidation of taking this ill-gotten money that the owner had boasted of getting as kickbacks from his employer, Apple, on overseas trips. And when the homeowner demanded payment, homeowner got upset. Hey, you didn't finish the job. Now it's going to cost me a lot of money to bring someone else in here to get it finished. He demanded payment from the contractor. The contractor's attorney responded with a matter-of-fact statement that litigation, quote, could result in Apple opening an investigation into plaintiff's relationships with vendors, end quote. Well, the homeowner pounced on this and sued for extortion, and the contractor's attorney, the suit was against the attorney, by the way. The homeowner sued the contractor's attorney, who filed an anti-SLAPP motion, arguing that his pre-litigation letter was protected conduct. But the trial court held that the letter was extortion. The Court of Appeal, fortunately, disagreed. The circumstances here did not fit into the egregious facts of the Flatley versus Mauro case. If you're ever dealing with extortion or alleged extortion issues, Flatley versus Mauro is a Supreme Court case that you need to look at. But instead, the court decided the statement was a permissible threat under Malin versus Singer, a 2013 Court of Appeal case, which recognized that certain threats to disclose information during litigation do not amount to extortion as a matter of law. And of significance, the court thought that it was important that the letter wasn't sent to the owner himself. It wasn't meant to get the party quaking in his boots. It was sent to the owner's attorney, so that was kind of a buffer that showed a sign of good faith rather than just trying to instill fear. And the letter was responding to the owner's demand letter, so it was a response to threatened litigation. It wasn't just coming out of the gate making these demands. And the letter defended the contractor on the merits. So it didn't just say, back off because I'm going to make life a living hell for you. It also, addressed the case on the merits. And the statement that litigation may bring the kickbacks issue into light was not a threat to report to prosecution or to prosecutors, but it was merely a matter-of-fact observation. This was relevant to the reasons why the contractor begged off the job. So it's going to come up, and that's going to create problems for you. You know, I'm just saying it. Not saying we want to make the problems for you. It's just a matter-of-fact statement that it's going to be a problem for you. So the court went on to find that the plaintiff failed on the second prong of the anti-SLAPP analysis to show a likelihood of prevailing on the merits. So the order denying the defendant's anti-SLAPP motion was reversed with directions to grant the motion, and the defendant contractor will, or the contractor's attorney will recover his attorney fees for both his motion and the appeal. And Jeff, just one final comment. I just thought that I was surprised that the trial judge found that that letter was extortion. It just did not seem like a close call to me, and it just leaves me a little cold that there are trial judges out there who would find that that kind of letter is extortion.
Yeah. This is a perfect example, Tim, of why AI will not replace lawyers in the context of anti-SLAPP litigation. I can't tell you how many times Flatley v. Mauro is cited for the proposition that, well, it's extortion and therefore exempt from the anti-SLAPP, when people are not familiar with the facts of Flatley, that there was a trifecta of threats made. I think it was to the IRS, criminal authorities, and immigration, that there was no real good faith attempt to negotiate the deal, that I think even the picture of the envelope and the header and everything was put in, as part of the opinion in this case. The facts of Flatley were so extreme, you put 100 lawyers and judges in a room, they would all agree that's extortion. This is not even close. And I don't think anyone should ever invoke Flatley without really immersing yourself in the extreme facts of that case. And if 100 people aren't going to agree it's extortion, don't raise it. You lose all credibility in an anti-SLAPP motion or opposition.
Yeah, no, that's a great tip. That gives me an idea. If we ever get a chance to interview someone who is promoting AI software for attorneys, or to replace attorneys or law clerks, which we'll share in a tidbit later, maybe we should give them the facts of this case and see how the AI would come out on whether this is extortion or not.
Yeah, it's a subtle distinction, but although it's a subtle distinction, the facts of Flatley are so extreme. It's hard to find a case that fits within those four corners.
Yeah, agreed. All right, Jeff, what cases do you have for us?
I have a couple short ones. The first one is unpublished. It's I'm going to butcher the name, Czodor v. Luo. That's CZDOR v. Luo, LUO. It's an unpublished January 10th case. But here's the reason I'm interested in it. And by the way, this came out of the 4-3. Involves the intersection of restraining orders and free speech and social media. You know, CHROs, civil harassment restraining orders, workplace restraining orders, and divorce restraining orders are special proceedings that allow someone to obtain a quick restraining order without all the trappings and burdens of a full-blown lawsuit. And most of the time, these restraining orders, whether it's CHRO or DVRO, they say stay away, don't own guns, and they end it there. But you get into these First Amendment issues when you start dealing with social media and future conduct and prior restraint, because sometimes trial courts go too far and they say, don't post anything on social media, which is a prior restraint. This case, although it's unpublished, is a great roadmap of the line between what is prior restraint and what is a lawful restriction on someone's social media use. And here, the person to be restrained was ordered to remove all the posts of the complaining party and not post in the future any pictures or likeness of the protected party if such pictures or likeness or posts would be abusive within the meaning of Family Code Section 6203 and 6320. So by narrowing it, instead of saying don't post anything, but say don't post anything that a court could conclude is abusive, they made it narrow enough to survive scrutiny. And so it was upheld. And even though it's an unpublished decision, it's a great roadmap of how to navigate the important protections against prior restraint with legitimate interests in protecting people seeking domestic violence restraining orders.
And is that you think that's narrow enough? Because it's not the court's not specifying anything other than don't violate the statute.
Yeah. So I guess there might be a vagueness challenge. I don't think there'd be a vagueness challenge facially, but as applied, possibly. But I imagine the person who's posting things about his ex or her ex on the internet probably has a pretty good idea from the specific case about what is and isn't abusive. And it probably has no legitimate reason to post pictures or likenesses of his ex. And so I don't know. I don't know that a vagueness challenge as applied would ever succeed in this context.
And is there a time limit on this order about restraining the future conduct? I think they always expire after is it 5 years?
So 5 years is the outer limit for these types of orders. Sometimes they're only for 1 year or 2 years, but you can always go in and renew them, and renewing them is pretty easy.
Yeah.
Yeah.
Well, okay, yeah,
So,
that's an interesting case. So it's a good roadmap for getting these orders that otherwise might fail as prior restraints by putting a narrowing provision in it.
yeah. And then the other case, I don't think any of our listeners need to hear this, but our other case I want to bring up is another unpublished decision, Mitchell v. Mitchell. Every once in a while, you have a case where you're working on the opening brief and you get fired up and you can't believe your opponent has done A, B, C, and D, or did A, B, and C below. And you put things in your initial draft that maybe make you feel good to write, but should come out of your draft. This case, Mitchell v. Mitchell, from January 27th, is another example of why you should take a deep breath and not do anything that's remotely close to attacking the integrity of the trial court or your opponent in a brief. The appellate case here did not issue sanctions, but issued a very stern warning and admonishment to appellant's counsel, because reminding the reader of the decision of appellant's counsel that once you make these accusations, either about the trial court or your opponent, and once it's filed, the opponent and the court must expend resources in defending against and processing the appeal. And an unsupported appellate tirade is more than just words on the paper. It represents a real cost to the opposing party and to taxpayers. And disparaging the trial judge is a tactic that is not taken lightly by the reviewing court. And counsel better make sure he or she has the facts right before venturing into such dangerous territory, because it is contemptuous for an attorney to make the unsupported assertion that a judge was acting out of bias towards a party. So a good reminder to maybe have somebody else read your draft and take a deep breath before you file it.
Yeah. As the court said, the opening brief is not an appropriate vehicle for the attorney to vent his spleen.
Yeah.
I was whenever I see these cases, these kinds of opinions that remind about the cost that frivolous or unsupported arguments impose on the other side and to the courts. I always find that interesting, and maybe there's something about it that could threaten to be a little chilling to litigants who they think it's a good case. Maybe the Court of Appeal has a different opinion, and are the justices sitting there thinking, I'm persuaded, and therefore you have wasted my time and the public's time and resources.
There's nothing chilling about or that would impact a lawyer from showing, not telling, but showing how a trial court acted with bias, or how a trial court flagrantly violated appellant's rights. You show it. The trial court did this, the trial court did that, and lead the reviewing court to reach that opinion. No lawyer is ever going to be sanctioned for explaining what happened below.
Right.
And if it's egregious, and as egregious as you think, the Court of Appeal will recognize that.
Yeah. There might be a nice, maybe it would be a good, useful legal tech that could take your brief and take out all of the conclusory remarks and all of the statements that are supported only by your own adjectives, and leave only what is supported by the record, and then see if it's worth sending it up to the Court of Appeal.
Yeah.
I've seen a lot of briefs that are only conclusions and adverbs, and not a lot of substance besides.
Clearly, you're right.
Okay. There were a few tidbits that I wanted to share, just some quick shots here. Let's see, there's one's been kicking around for a little while. I just want to share it. I thought it would be interesting for anyone who is working on a writ petition. Here's some nice language from a published opinion a few months back about writ relief. This kind of provides a nice roadmap mental roadmap and a roadmap for your brief. Here's the quote. It is appropriate to review discovery orders via a writ of mandate. This is a case about a discovery order, obviously. It's appropriate to review via writ of mandate when we are presented with a question of first impression, which is of general importance to the trial courts and to the profession, and in conjunction with which general guidelines can be laid down for future cases. That quote is from Rudnick versus Superior Court. It's a 1974 case, oldie but a goodie, something to bookmark for your writ petition file.
Yeah.
All right, and then here was this interesting bit about under the heading, should AI replace law clerks?
No.
Okay, so hear me out, Jeff, or hear out attorney Adam Unikowski, who has written a series of posts on his Substack blog about the various areas where AI might replace human lawyers, including writing arbitration awards, because arbitration is voluntary, at least nominally, and even writing initial drafts of judicial opinions. Here's what Mr. Unikowski says. He says, in the shorter term, AI could, and in my view should, serve the same role that law clerks play now. The AI would review the briefs, summarize the arguments, and make a recommendation as to how the case should come out. After the judge decides how the case could be resolved, the judge should summarize the rationale. The judge could summarize the rationale to the AI, and the AI could then prepare a draft of the judicial opinion based on that rationale. And the judge would review and edit. The AI would cite check and offer further comments, and the opinion would then be released, presumably with the final check being a human judge. But the benefits of AI for this purpose would be twofold: accuracy and speed. And Unikowski had mentions the old adage about justice delayed is justice denied. So AI could step in and come to the aid of those who have been waiting years and years and years for a result in this case by speeding up the process. So
what about justice being denied being justice denied by having a robot be the filter for legal arguments? I'm not comforted by this article.
All right, well, Jeff, you ran your own experiment on this, so tell us about that.
Yes, I'm here to tell you that AI has determined and declared that AI is not ready to be used for law clerking. I'm a big fan of Notion. I use that product, and they have an AI beta going on right now. I had it write an article about, the prompt was, should AI be used to replace law clerks? And the spit out of 6 paragraphs that I got from VAI said this is an issue that depends on the individual needs of the particular project. And while AI technology offers the potential for increased efficiency, it's important to weigh the pros and cons carefully before making a decision. This is a clear threat that Skynet is right around the corner, and that we should not use AI to replace our justice system.
Well, all kidding aside, I do. I was alarmed to see someone supporting the idea of judicial opinions being written by AI. I don't think we're quite at that level yet, where we're still just being introduced to the possibility that AI can write sentences in whole paragraphs that might fool people into thinking that they're being written by human beings. And now we're talking about deciding people's livelihoods and lives in judicial opinions through the use of AI. That is scary.
Yeah, I've got 2 thoughts here, Tim. One of these days, we should do an episode where AI writes all of our dialogue, and we'll just read what the AI wrote. We'll see how that goes. And then number 2, on the issue of AI being useful in some spaces, I use Westlaw. I think they have a thing called brief check, and I use case text. They also have a brief check thing where you can put in your opponent's brief and put in your brief, and it'll spit out the universe of cases you should be reading. I think that's a great application of AI, maybe to give you the universe of cases to at least start your research from. There are limited uses of AI, but I'm not ready for AR to start driving my legal car.
No, I agree with you. I think this seems a little bit jumping ahead to me. There are a lot of applications of AI before we jump ahead to consuming our written content. Replacing all the content, written content that we consume with AI content. That seems jumping rather far ahead. Okay, the next topic, next tidbit. The Supreme Court California has granted review in a couple of civil cases, one of which is the $2.5 million sanctions award in Los Angeles versus PricewaterhouseCoopers. The PricewaterhouseCoopers case held that unless there is a specific section of the Discovery Act authorizing it, an award of sanctions may not be imposed. So that case actually reversed a trial court's $2.5 million award of sanctions. It was awarded to the city of against the city of Los Angeles for its egregious abuses in that PricewaterhouseCoopers case. So that award was reversed, but there was a very what I thought a persuasive dissenting opinion by Justice Grimes, who raised a point that I thought devastating. She noted that there is no specific provision in the Discovery Act either that sanctions that sanctions the spoliation of evidence, but if the Discovery Act sections authorizing sanctions do not authorize sanctions in the PricewaterhouseCoopers case, then the majority's holding has rendered spoliation as well as the other egregious wrongs the city of Los Angeles had committed in that case as mere wrongs without a remedy. So this is just another one of those cases that the law can not do anything about unless the Supreme Court grants review, and the Supreme Court did grant review. So we'll stay tuned to see what happens there. Okay, there was on the subject of sanctions, there's another case where $69,000 in appellate sanctions were imposed by the 6th District. This was $60,000 awarded to the respondent, plus another $8,500 to the clerk of court against an appellant and his counsel. In an unpublished decision, the court held that given the clear application of the law of the case doctrine in this instance, we conclude that any reasonable attorney would agree that the appeal is totally and completely without merit. The court also noted that the appellant's brief misrepresented the record and also played fast and loose with the substantial evidence standard. Significantly, the substantial evidence argument in the appellant's brief misrepresents the record and misapplies the standards of appellate review. And finally, the purpose of the appeal appeared to be to delay contempt proceedings against the appellant. So those are all big no-nos that resulted in a $69,000 award of appellate sanctions.
Interesting. Hey, did the Supreme Court grant review together, like it's hearing those cases together to decide this issue about sanctions powers, or are these two unrelated grants?
Oh, yeah, this is an unrelated case. There's not, as far as I know, not been review granted on this $69,000 sanctions case.
All right. And did justices decide to grant review, or was it AI that determined whether or not these were appropriate cases for review?
That's how would we know unless the justices just volunteer that information?
Yeah. Okay. All right. Stay tuned.
Okay. And then finally, last tidbit. There's currently a heated debate in the Third Circuit, Federal Circuit Court of Appeals, about whether the filing deadline should be midnight or 5 p.m.
Midnight. Sorry, go ahead.
This has prompted analysis of when appellate filings actually occur. So there's been a study of when are attorneys actually filing their briefs. And so in a study of about over 1.3 million docket entries made in the courts of appeals in 2018, most were made between 8 a.m. and 5 p.m., about 89%. After 5 p.m., the filings, about 8.9% of the filings were after 5 p.m. But if we're just talking about briefs, that number goes up to 15%. And after 6 p.m. Of all filings, about 4.9% are filed after 6 p.m. And if we're talking about briefs, it's 10%. So, so what does that come out to? About 25% of briefs in the Court of Appeals are filed after 5 p.m. So yeah, don't change the midnight rule.
What is the problem they're trying to fix here? Here's the question that maybe your crack team of law clerks there at your firm can solve. How many, let's see, 25% of these briefs were filed after 5 p.m. So 75% were filed before 5 p.m. What is the success rate of appellants opening briefs for the rushed briefs filed after 5 p.m. as opposed to the steadier briefs filed before 5 p.m. I wonder if there's a material difference in the reversal rate.
Well, that would be fun stat to have on hand. But to your first point about what problem does this solve, are the judges waiting around, at the end of the day, hoping the briefs come in so they can start reading them?
When is Tim's brief going to be here? I can't wait to read it. That's what they're saying.
Now, I think that may be true of my appeals, but I don't know about yours, Jeff.
Run out of briefs to read. I need another brief on my pile. I don't have enough to read.
Yeah. No, I think every attorney breathed a sigh of relief when those electronic filing rules came out and allowed filing to be done up until 11:59 and 59 seconds. I don't think anyone is looking for would be hoping for that rule to roll back to 5 p.m.
Yeah, I'll say though, when you've got a brief that's filed in the middle of the day and you get the feedback within an hour whether your brief's accepted or not in terms of technical requirements, when you file in the middle of the night, say 11:59, you have no idea if your brief is technically compliant and will be properly filed or accepted. So best always to file before 5, but please don't change the rules regarding midnight.
Well, yeah, that's right. If the clerk processes it during the same day that you filed it, then there's no question about when if it's going to be stamped on the same date you filed it, or maybe the day later when the clerk processes it because you filed it after business hours. So always a better practice to file it sooner rather than later. But okay, well that's the last of my tidbits for today, Jeff.
All right. I think that wraps up this episode. Again, we want to thank Casetext for sponsoring our podcast. Each week, we include links to our cases that we discuss using Casetext, and listeners of our podcast can find a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
If you have suggestions for future episodes, please email us at info@calpodcast.com. We're always interested in hearing your suggestions for guests that we should have on the show or topics that we should cover. And in our upcoming episodes, always look for more tips on how to lay the groundwork for an appeal when preparing for trial.
But only send us human feedback. We don't want AI feedback. See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.